my name's Ian Wallis. I work for the Victorian Chamber of Commerce and Industry, and I'm part of the Health, Safety, Wellbeing team here at the Chamber, and I'm glad you could join us today for this quite interesting and no doubt popular topic that we're examining. So what we're going to cover today is background and lead up to these new laws, these changes, their commencement date and one or two issues around the commencement, some new, the details around the new offences, various, layers of liabilities and various exclusions that have been included in these new workplace manslaughter laws. We are going to talk about, the legal tests. So issues around definitions, conduct, negligence, and causation, and I guess what those legal tests look like and how the courts will be interpreting those, at least based on what we know to date. We will then touch on a little bit of jurisdictional coverage, so where these laws apply, and how they might apply in Victoria and outside of Victoria as well. There are some changes to timelines, and so we'll talk about those and Statute of Limitations. And then a little bit about what we can offer to support you, but also what to do next and how should we respond. Just a quick summary slide around that. So thank you again for attending, and we'll move into the materials. So beginning with a bit of background, a little bit of history leading up to these changes. So in 1994, Australia essentially, received its first workplace or a corporate manslaughter prosecution. A company called Denbo Proprietary Limited and the director, Timothy Ian Naden Bush, were charged under this under the criminal manslaughter provisions. And this was the first Australian manslaughter provision based in a workplace that Australia had seen. Essentially, Mr. Justice Teague at the time of the Supreme Court fined Denbo Proprietary Limited, an earth-moving company, $120,000 for criminal negligence in causing the death of Anthony Krog 3 years earlier. There appeared in this case to be little that was controversial at the time. Both the company and one of its directors, and Timothy Naden Bush, were committed for trial for manslaughter, although the director's charges appear to have been dropped in the case in exchange for a guilty plea for the company. Historically, the various manslaughter provisions have generally been accepted in the US and England, but was never contested in Australia. And this case did not contest it either. It was a guilty plea and a financial penalty, and it wasn't never challenged. So as such, this single case represents a bit of an ad hoc start in '94 to the idea of corporate manslaughter. Little attention was paid to it at the time. However, it is, one of our early precedents. In 2001, the Bracks government then attempted to introduce into Parliament new laws for workplace manslaughter offences. The government was unsuccessful in doing so at this time, in no small part because of the strong opposition of employer groups, including the Victorian Chamber of Commerce and Industry. But also they did not have the majority in the upper house to get these laws passed. However, this bill did contribute to the development of the current reckless endangerment laws that we have that reside in the Occupational Health and Safety Act. 2004. So the current laws that we do have essentially reside, or the most serious penalties sit within Section 32, the reckless endangerment provision of the Occupational Health and Safety Act in Victoria. So this was, in 2016, these penalties were increased under reckless endangerment to up to $3.2 million. And so that is our current maximum penalty available. And up to $285,000 for an individual and up to 5 years jail for corporate officers. So this offence relates to the risk posed to employees, to workers, and not the outcome of the incident, such as an injury or death. So it's actually more about the risk and the hazards in the situation rather than the outcomes. Now, while the reckless endangerment offence has been in place, there's really only been one instance where an officer, a corporate officer, has been jailed as a result. So, not a lot of certainly personal penalties as such. A little bit about the national trends. So there's been I guess, a growing momentum, and this originates out of the United Kingdom as well, where they have a corporate manslaughter, have had a provision in place there for some time. But in Australia, there's been a growing trend, and there's been a Commonwealth Senate inquiry into the framework surrounding prosecution for industrial deaths in Australia. There has also been a review of the model WHS laws by Marie Boland, and this included a recommendation for a harmonised workplace manslaughter provision to be included. And there's also been the Northern Territory has had a review of their workplace health and safety legislation, again recommending and now adopting workplace manslaughter within the WHS Act in the Northern Territory. And there's also been a federal Labor commitment to introducing a national workplace manslaughter offence across the board. Current state of play in terms of laws in other states. So in Queensland, I guess was more recently the most, I guess, the strongest WHS laws. So in 2017, they introduced the industrial manslaughter offence. And we've only just now seen the first conviction in Queensland, with penalties handed down just a couple of weeks ago in June this year. And that, quite serious penalties of $3 million for the corporation and 2 directors receiving suspended 10-month jail sentences. But that is the first within Queensland, and indeed the first in Australia. The ACT has had industrial manslaughter since 2003, but they have had no convictions to date. And there's a bit of some barriers around that law. Northern Territory has voted to accept and indeed introduced their version on the 1st of February 2020. There is a workplace manslaughter bill introduced to the West Australian Parliament. And New South Wales particularly note that they reviewed the law, but rejected including workplace manslaughter in their legislation, but included a bridging section referring to the Crimes Act in these circumstances. So now if we fast forward to pre-election in Victoria, where we saw Daniel Andrews giving a pre-election commitment to introducing workplace manslaughters in Victoria. And so he has continued with that commitment and been true to that statement, and implemented the draft, or the bill that has now been turned into law. During that process of implementing the bill, the Andrews government established an implementation task force. And it was a consultative group that was not able to look at the policy merits of the law and its impact on businesses and the economy, but was given the task for implementation of the law only. But that included a 5-group employer organisation, a group who worked together, including obviously the Victorian Chamber of Commerce and Industry. But there are also employee and union representation, and indeed, notably, there were family members who were included in that group as well, families of people who had died at work. We have worked with 4 other employer representatives on the implementation task force, and we've also worked closely with 12 members of the Victorian Congress of Employer Associations, sharing information and coordinating our collective responses. Which brings us to the new laws themselves. So the Workplace Safety Legislation Amendment Bill 2019, Workplace Manslaughter is the official title, and that was voted into law, and that will commence on 1 July. So in just under 2 weeks' time. And so certainly there's, accelerating interest, as everybody can expect. So we'll get into the law itself and the key features. So to begin with, the entire amendment involves a new Part 5A under the OHS Act 2004, with sections 39A to 39G included. So there's initially new objects. So the objects of these amendments are to clearly prevent deaths, to deter people who owe certain duties, and we'll clarify those duties, and to reflect the severity of conduct that places life at risk in the workplace. And historically, as we've already alluded to, generally the community feels that these laws, penalties particularly, have been somewhat low. And so penalties like 6 months jail and $250,000 fines for triple fatalities have received quite a bit of community attention and concern. And so these objects reflect, the concern and the changes that we are seeing. So the offences. So essentially we have 2 new offences for workplace manslaughter. And these are designed to capture negligent conduct, which causes the death of an employee or a member of the public. So the first offence applies to organisations such as body corporates, partnerships, unincorporated bodies and unincorporated partnerships, and self-employed persons. This also includes, as is normal, includes Crown and government departments. So 39G Part 1 talks about the person, including an organisation. The definition of a person includes an organisation and the self-employed. Person who is not a volunteer. That's an important point to note. Volunteer directors and board members and senior volunteer executives are excluded from these particular offences, and that's consistent across the board. So the first penalty is a person, the organisation as well, that is negligent, is in breach of an applicable duty. So we'll talk about the applicable duties, and then causes the death of another person. So causes is an important term, and causation is important. And please note the offences. So it is now up to 25 years imprisonment, which is up from a much lower level of potential. and up to 100,000 penalty units, which equates to $16.5 million in the current financial year. Now, some of you may note that you thought it was 20 years imprisonment was the maximum, but the workplace manslaughter, well, the manslaughter provisions across the board, all of the manslaughter laws have just been amended and will have an increase to 25 years potential imprisonment as of the 1 July as well. So it's a separate amendment outside of these laws, but it went from 20 to 25 years in potential imprisonment. So the 25 years will be the current and correct length of imprisonment that's possible. In addition to these penalties, there's obviously additional sanctions under the OHS Act and the Corporations Act that can also apply. For example, if a corporation has no assets or liquidates or is a non-profit, then further sentencing options are available to the courts. Options like disqualification orders, adverse publicity, improvement project orders, and other alternative sentencing enforceable undertakings as well. But these will only act as, I guess, in addition to the penalties that we're talking about, which are the primary ones. So the second offence, the second offence relates to corporate officers specifically. And so these continue as in section, I think it's 144 under the Act, relates to corporate officers as defined by the Corporations Act, the Corporations Act 2001. And again, they are not a volunteer director or corporate officer. So corporate officers and people in senior positions essentially must not engage in conduct that is negligent, that is in breach of any applicable duty under the OHS Act, and then causes the death of that person. And in this case, it is a potential prison sentence that we're talking about, so up to 25 years. Now, this second offence applies to officers, as we said, described, and officers under the Corporations Act who are responsible for entire or substantial parts of an organisation, including the financial matters. So entire or substantial parts of an organisation. And that may include not just the typical idea of directors or chief executives. There is a charge before the courts for a senior engineer at the moment being charged as an officer for a breach of a decommissioning construction site. A senior engineer who was the responsible person for that site and being charged as an officer, which is of interest. So it really is aimed at those with practical, senior management and control. It's been stated that the maximum penalties have been designed to create a greater deterrent for organisations and officers for breaching these OHS duties. But also, remember, as I said, there's other sanctions under the Commonwealth Act, Corporations Act, 2001, that can disqualify a person from acting as a company director, for example, if they are convicted of a criminal indictable offence. And so, there are consequences that may occur beyond these immediate laws for those who may be found guilty. These laws all hinge on the applicable duties, or these penalties rather, these increased penalties, all relate to the applicable duties and exclusions. So section 39B defines the applicable duties. Well, it actually defines the exclusions rather than the other duties. So there are two key exclusions, and they both relate to employees. So under section 25, duties of employees. So employees are excluded. And then under section 32, reckless endangerment of an employee is also excluded from these applicable duties. So this is a step in a different direction from the way the OHS Act normally applies. The underlying principle has been, shared duties across the board. Not all the same, of course, but shared nonetheless. And this is a bit of a step change and a diversion from that. So by talking about exclusions, what it's then inferring is that all of the other applicable duties are then included. And that means the general duties of care that employees have under sections 21.1, 21.2, 21.3 to contractors and subcontractors. The duty to monitor health and conditions at work under section 22. The duty to visitors and the public, 23. Managers and supervisors, and those who manage and control. Those who design, manufacture, supply, install, or indeed have other regulatory duties in the regulations 2017. And so these are, quite broad, wide-ranging applicable duties that continue and essentially have far more serious penalties that are in place for workplace fatalities. There's an intention and a stated intention, both in the explanatory memorandums and in Hansard, the debate record, that rogue employees are still, subject to these other duties, and indeed can be prosecuted under section 25 or indeed section 32, and being held accountable for any so-called reckless acts that endanger people. So those provisions still continue and will do so. They remain unchanged. But the employees can't be held accountable under the workplace manslaughter penalties. So we do need to talk about the tests. So these are the tests the courts will apply. And the first, I guess, definition that has been provided in the OHS Act is section 39C1 around conduct. So in summary, conduct includes and means the acts of organisations or senior people and or omissions. An omission to perform a prevention or a preventative act, for example. So this includes, potentially dangerous practices that may have actually began before the commencement of these laws, but continue past 1 July, and then people have, or continue to fail to prevent them after 1 July. And that also may be captured. So an organisation's negligence may arise in different ways. There may be as a result of accumulation of conduct by different individuals. It may be based on unwritten rules or accepted practices that are not official, or indeed, more overt acts or omissions. And we also need to remember that the OHS Act broadly, and now these new penalties, do include psychological hazards and potential injuries as well, what's called the psychosocial hazards and injuries. And they also strengthen the responses around serious illness that may actually lead to fatalities as well. Things like silicosis, asbestosis, etc., now become far more, I guess, they're within the scope of these penalties. Along with that, there is the negligence test. So section 39E talks about negligence. And so I guess this is talking about the standard of the test. So this is worded in the Act as a great falling short of the standard of care that would be expected by a reasonable person. Please note the wording, the great falling short. So not just a falling short, but worse. Perhaps gross negligence might be, a similar, the word gross negligence is a similar test. But it's also worthy of note that this includes not just death, but also the risk of serious injury and serious illness. And I guess the point is made here that serious injury and illness may eventually lead to death. And, it might be just the circumstances of the situation that happens. So this is an important point. When we think about risk, the law talks about the risk of death, but also serious injury and illness that we need to consider. Now, the reasonable person test, I guess, I've included a bit of a definition here in the slide, which is, one of the well-regarded, very common definitions around this. So the standard requires one to act with the same degree of care, knowledge, experience, fair-mindedness and awareness of the law that the community would expect of a so-called reasonable person. And this is a long-established test in common law and very, very well defined by legal precedent. And this includes a reasonable organisation, and behaving in this way. So it's a great falling short of that standard is the legal test. Just continuing on from that, so in determining if the conduct is negligent, what matters is actually the conduct itself, not so much where it came from. And the wording is something like, it does not matter whether the conduct is or is not imputed by the body corporate, by an employee, agent or officer. It is also conduct by the body corporate. It doesn't matter whether the body corporate's officers were involved in all or any part. And so what this inclusion is talking about is that historically, before these types of laws, a corporation could only be found liable where the conduct could be attributed to a specific individual. It's called the identification doctrine, or the directing mind and will. And this doctrine really has been less and less effective in modern and decentralised corporate structures. And so this inclusion aims to overcome the problems and the barriers created by this identification doctrine. And so basically it says it doesn't matter whether it's one or more people, or, if the conduct occurred, then a corporation can be found to be prosecuted and guilty under these sections. It doesn't have to be specifically linked to a single person. Courts will also, as usual, have regard to any steps taken for minimising the risks and as mitigating circumstances as well. So that's that hasn't changed. Continuing on the causation theme, so these laws state that whether the conduct causes the death would depend on the facts of each case. So there has to be a very strong causation, a causal link. So the conduct is proven to lead to the fatality. Now, I guess the words again included in these laws is that the conduct, whether the conduct contributed significantly to the death. So case law provides that, there's a fact that conduct can contribute causally to a result, but in this case, the words chosen are contributed significantly to the death or the result. So this is alluding to a strong causal link that is needed between the conduct, the negligent conduct, then leading to the fatality and a significant contribution. may not be the only contribution we need to note, but it must be a significant contribution. So quite a strong causal link is expected. Talking about some jurisdictional features. So essentially these laws are Victorian. So it centres on issues that, or activities that occur in Victoria, but certainly, and it's stated explicitly that this can involve conduct that results, so the conduct occurs outside Victoria, but results in a fatality within Victoria. So a company in New South Wales with a head office in New South Wales, for example, can be prosecuted for a death in Victoria. Conversely, a company in Victoria can be prosecuted for the conduct that occurs in Victoria. The incident may occur in Victoria, but the death might occur in another state. So someone dies of a serious illness in a New South Wales hospital, but the conduct and the exposure occurred in Victoria, then that can be included as well. So this is, obviously intended to make sure that the conduct itself is the focus, not so much where the death occurs. Now, there's probably several questions about employees internationally. Essentially, it would be far more difficult, not impossible, but far more difficult for WorkSafe Victoria to run a prosecution for a death that occurs internationally. And I'm not sure that we've ever seen that. So, yeah, just practically quite limited. In terms of the timelines, so there are amendments around the Statute of Limitations. So the Statute of Limitations is currently set down in section 132, and that is a 2-year limitation. So that means WorkSafe need to bring to a court the prosecution within that 2-year period once they become aware of the need to do so. So this 2-year limitation has been removed for workplace manslaughter. So WorkSafe currently, investigate these, of course, in accordance with the OHS Act, and that, the process continues. And in this matter, WorkSafe have increased their resources. So they now have a specific fatalities investigations team established that are a group of ex-police detectives. And so WorkSafe have increased their resources around this area. So they are better equipped to pursue this line of inquiry and potential charges. So the reason the 2-year limitation has been removed is because typically, and based on the British experience, most of these investigations take much longer. So typically around 3 years on average, but it also, I guess by nature, begins to include a death from a longer term illness. So we need to be aware that, silicosis and asbestos related illnesses, may well be included, and that's certainly been stated by the government also. With the removal of this 2-year limitation. It's just a point to note, it won't have an impact or an effect for employers directly, but just something to note is that these laws create a workplace incidents consultative committee. And this is designed for the government to remain in touch with community expectations around workplace deaths. Employers and such are not likely to be involved, but it is focused on the government remaining in touch with interested parties in the community, in particular family members who've suffered the loss of their loved ones, that sort of thing. So it's just a point to note that this has been included, but employers won't be directly involved as far as we know at this point. So that's a summary of these laws. So what does this mean for employers in particular? So I guess overall, these proposed laws, these increased penalties, won't impose any new OHS obligations on businesses that are already compliant. It doesn't change the applicable duties of care of the OHS Act. It does, however, strengthen and dramatically increase the threat of significant penalties. And that should motivate organisations to conduct reviews, to review how they manage, they eliminate, manage and control potential serious injury and illness and workplace fatalities. And just reviewing and ensuring everything in an organisation's capability is in place to make sure that doesn't happen. And the Victorian Chamber is busy developing a range of these commercial offerings, these webinars included, some short videos, but also tip sheets and other online resources that are available to members in terms of how and what to do in approaching these legal changes. So please let us know if you're looking for any specific assistance. We have a strong team of seasoned health, safety, wellbeing consultants who can assist in this regard. But in summary, what employers need to be doing in response to these laws is formally reviewing and revising your fatality hazards and risks and enhancing your business injury and fatality risk registers. And in particular, reviewing the corrective actions, making sure the current actions are in place and effective and are ongoing, and adding any additional corrective actions that you feel may be needed to bring the hazards and risks to a tolerable level. So that means, below high or extreme hazards or risks, moderate or less is where they need to be. And ensure this is conducted in a consultative way. This is also a legal requirement that employers engage and consult with all the relevant experts, the hands-on employee experts, the HSRs, particularly as a legal obligation if you have them, but also the technical and the process experts. Make sure that a consultative approach is taken and it's not just one person's opinion. One thing you need to note is that we need to seriously think about the longer term periods. These fatalities are often rare and catastrophic, and they might be a 1 in 20 year disaster. Most businesses think in financial, in terms of return on investments, in 3 to 5 year, if indeed they're planning, on those sort of strategies. And sometimes there's a bit of a disconnect between, the long-term disasters versus the way typical businesses think. We need to think much longer term for a sustainable organisation. And to be thinking, far more longer term. We need to also make sure that our corporate attitudes are strengthened against accepting high risk or extreme risk activities in order just get it done this time, or we're really busy and we haven't got time to take the right hazard and risk actions. So business gets busy and resources become challenged, but we need strong leadership attitudes to make sure that we do not ever accept high and extreme risks to the best of our abilities. And we need to make sure we gain assurances, documented assurances, and then monitor the fatality risks and controls are in place and fully effective. Thank you all. Appreciate you attending, and and I hope you have a good day. All right. Thanks, folks. Goodbye.